Welcome to the Military Justice Today podcast with your host, Robert Capovilla and Mickey Williams, covering the full range of military law topics from all branches of the armed forces. Today's episode is made possible in part by the law firm of Capovilla and Williams. And now, let's welcome the hosts of the show, Rob and Mickey.
All right, everybody, here we go. Another episode of Military Justice Today. I'm Matt Staroziak in the podcast studio outside of Atlanta, Georgia. Sitting next to me is my colleague and good friend, Robert Capovilla. Hey, Robert.
Hey, Matt. How are you?
I'm doing great. How you doing today?
I'm good, man. I'm very good today.
Nice day in Metro Atlanta, isn't it?
Yeah, no, can never complain about 80 degrees and sunny.
No, never. And I am pleased to announce that we have, I'm not going to call him a guest because he's an attorney at the firm now, but we've got Chris Jones on the line. Chris, are you there?
I am.
Great to have you with us, sir. This is your first time on the podcast, right?
It is. I'm very excited to be here.
Well, we're excited to have you. We're going to talk in a minute about your background a little bit, but you are a retired Air Force colonel. Now, I'm the non-military guy of the group, so I get the ranks of colonel and general mixed up sometimes. Robert, you were a general, were you not? You were a general in the military.
No, that's 100% not accurate.
You were not a general.
No.
You were a colonel.
And just so we all know, Matt's got a big smile on his face because Matt does know the difference. He's just giving me a hard time because JAG is Judge Advocate General, so he's poking fun at the fact that some folks have legitimately asked me if I was a general, and the answer is no.
You said a 1-star, just a 1-star.
Yeah, no, I was never a general officer. I was never a full-bird colonel. Chris, however, was a full-bird colonel, which is an exceptional accomplishment, and for those unlike Matt who know, they really only promote the best of the best above 06 and or 06 and above, and it's an incredible accomplishment for Chris.
Well, Chris, it certainly is.
I appreciate that.
Without a doubt, it's an honor to have you on the show, and we're going to get a little bit about your background. In fact, why don't you tell us a little bit about? It was 20 years, or very close to 20 years, or over 20 years that you served, right? And then why don't you tell us a little bit about your military service and maybe what you enjoyed most about it?
Oh, thank you so much. Well, that's correct. I served just a bit over 20 years in the Air Force. I was a JAG that entire time. Most of that 20 years was either spent in litigation or as advising on federal employment law matters and criminal matters. And so that was my focus for 20 years. It was a heck of a ride, I'll tell you that. And then after that, I was able to work at the Department of Veterans Affairs, and I did labor and employment for them as well. And again, it's been a long time, right? 21 years of practicing and being a litigator and being in the courtroom. And I've enjoyed it, and I'm really excited to be here with Capovilla and Williams and helping people who need it.
How are you enjoying things since you've been out? Is it the same as what you thought? Is it different than what you thought? Do you ever miss it, I guess?
I would say that it is somewhat what I thought. I will tell you that the weight of the uniform is heavy, and I think all of our service members who have served, whether you're talking about Rob or the folks that we're currently serving as clients, it is a heavy weight to wear the uniform and be on duty 24/7. And so when you're able to retire or separate and get that weight off, it is a heck of a relief. And I'm thankful for my service. I'm thankful for the things I've learned, but it is a stressful way to live. And it just weighs on you when you're talking about putting people in harm's way and frankly, the power and authority that the military has over its members.
Yeah, that's exactly right. And I'm proud, Chris, that you haven't done what some folks do, not that I'm judging, which is go get a bunch of tattoos, grow out a Jeremiah Johnson beard, and buy a Harley Davidson. Although I can't blame those guys because the weight of the uniform is pretty heavy, and a lot of those guys that retire after serving all those years, they want that release.
Well, I would love to grow a nice long beard and show off that I'm retired. Unfortunately, that's not in my genetic coding.
There you
Understood.
Well, let's kind of jump into today's topic, which is going to be federal employment law, an area that is obviously near and dear to your heart, Chris, that you've done a long time. You've got a tremendous wealth of information, and we plan on digging into as much of it as we can over the next half hour or 45 minutes. But with that being said, Robert, do you want to ask the first question, or do you want me to?
Oh, I'd be thrilled. And this is a very basic first question. So, Chris, for our listeners who are primarily military members, a lot of veterans and things like that, they may not really be, they may not be associated with or even know what federal employment law is. So what's kind of your definition when somebody asks you, what is federal employment?
I would describe it as the group of all of the rights, benefits, and processes of what it means to be a federal employee.
And so, like any area of law, there's got to be regulations out there. There's got to be rules out there. There's got to be statutes out there. Where is federal employment law codified?
That's exactly correct. It's not only in statutes. Everybody knows about Title VII of the Civil Rights Act. I think we've heard that term thrown about, but there's statutes that are passed from Congress. There's the Code of Federal Regulations that lay out a lot of the processes of how these rights can be exercised by federal employees. And then, of course, there's federal case law. Those are the opinions and decisions of federal court judges across the country. You have administrative case law from the administrative law judges. And then, of course, we're talking about federal agencies. And there are a bunch of federal agencies beyond just the Department of Defense or the Department of Veterans Affairs, many of which most people haven't heard of unless they work with that agency. And so each one of those agencies has regulations and processes that need to be followed. And that also, is another way it's codified as far as the rights of those employees who work for them.
Now, Chris, let's take a step back here because we talked a little about your military experience. You talked a little bit about your experience in the federal employment law arena. But where did you learn all of this? I mean, where did you, how did you become the experts you are in the federal employment law arena?
Well, it started a long time ago, back almost 12 or 13 years ago, as I started dealing with these issues specifically in this arena. I was so fascinated by it. I wanted to stay in litigation. I wanted to stay in the courtroom fighting. And so I actually was competitively selected to get a master's of law, which is another degree above a law degree. And I got that in labor and employment law. So I spent an entire year, fortunately for me, on the Air Force's dime to get this degree and go back to law school at George Washington University and focus on this. And then as soon as I graduated, which I don't want to toot my own horn, but I graduated with the highest honors, which was pretty cool. I was able to immediately get into a labor and employment law position in the Air Force so they could utilize that degree. And so I immediately went into to Florida, and I represented the Air Force in all of its labor and employment issues across the state of Florida. I dealt with union issues. I dealt with disciplinary issues. I dealt with discrimination issues. And that was the first time I dove headfirst into it. And frankly, and Rob, I'm sure you know this, once you start showing your skills and your experience in any area of law in the military, what happens? They immediately say, well, shoot, we're going to take advantage of that. And frankly, even if I wanted to, which I didn't, even if I wanted to, the Air Force didn't let me ever get out of that because they went, she's got all this experience, right? Let's keep using it. And I kept using it for the remainder of my time in the Air Force. And then, of course, into the Department of Veterans Affairs.
And now you run the Capovilla Williams Division of Federal Employment Law. So my next question for you, my friend, is, what types of issues come up that could lead to somebody, a federal employee, needing an attorney on a federal employment law matter?
Great question. Like I said, I think most people are aware that there are anti-discrimination laws out there, and recognize that if they think they've been discriminated against, that they probably need a lawyer. They probably need to at least talk about a potential case. But there's a lot of other stuff out there. You've got the Pregnancy Workers Fairness Act is relatively new. Agencies are still trying to figure out how to make sure they're applying that properly. You've got reasonable accommodations when we talk about telework. And that's a big one, right? Because the federal government in the past couple of months has drastically changed. Every agency is ordering people to return to office. And so now you've got a lot of reasonable accommodation claims that are out there. You also have due process rights when it comes to discipline. You have the rights of, a lot of bargaining unit employees. Bargaining unit employees are those employees who are part of the union at their agency or at their location. And so you have all of these interwoven laws and rights. And it's very, very complex. You just asked me about where's it codified. So you've got all of these rights, you've got all these different sources of information, and it's just really important to find someone who can navigate all of these different issues and have a strategy of how to navigate them for what's best for their client.
Chris, you brought up discrimination. And so what if an employee thinks they were discriminated against? What options do they have? I mean, how do you typically advise, a client like that?
Well, the first thing I want to do is I want to develop a relationship with the client, and I want to understand what they're going through. There are a number of ways we can deal with the discrimination claim, and the starting point has to be that understanding what they've gone through, how they were discriminated against, and more importantly, how are they going to prove it in trial if we have to get to that stage.
And so just kind of talking generally about this, what is the difference between taking a case to the MSPB versus the EEOC route? And I guess also kind of explain what those two things are.
So the Merit System Protection Board is a separate agency that is designed to make sure that employees' due process rights are followed. And so that is an avenue for generally people who are facing some sort of disciplinary action. They can bring a case to the Merit System Protection Board in certain cases. So that's one option that employees might have. Another option employees might have is to bring a complaint through their agency's EEOC, Equal Employment Opportunity Commission program. To bring a complaint to their EEOC program managers to say, hey, I feel I've been discriminated against. And that starts another process of an investigation and potentially litigation or a hearing before an administrative judge. So in a lot of cases, those are the two choices that a federal employee might have if they say, hey, I think I got in trouble, not because I did something wrong, but because really my supervisor or somebody else is out to get me, or they're discriminating against me based on, my protected class, whether that's my skin color, my race, my religion, my national origin. These are all those types of issues that can come up. And so that's really the first question is, where do we think it's the best avenue to investigate and cite this discrimination?
Chris, hey, it's Matt. I want to jump back in just for a moment and ask you a couple questions, I guess, from the client's perspective. I don't have the training that you and Rob have on these issues, but from the client's perspective, I guess maybe a couple of questions. One, how do they determine, at least initially, now they're not going to be able to make a legal determination, obviously, but how do they determine initially whether or not something that's happened to them is a violation of their rights or the law? I mean, because obviously there's a stern conversation you might have with your boss that is well-intentioned and okay. And then you might have something else that happens to, a federal employee that's not okay. How does the average person kind of go about determining that? What advice would you give to them for determining whether or not they might have a claim and should seek legal counsel?
Again, a great question. I think it's really hard for a lot of employees because you don't realize it's almost putting a frog in boiling water. As that water heats up, the frog doesn't realize how to jump out quickly and how to find a solution. And so a lot of employees have to deal with, there's an incident with their boss and they maybe think nothing of it. Maybe it hurts their feelings, but they think nothing of it from a complaint standpoint. And then a couple of weeks later, something else happens. What really, Matt, you're describing is a pattern of harassment. And employees are free from harassment or should be free from harassment. Let me just remind everyone, there are all of these laws to protect the rights of employees to come in, do good work, and go home. And if there's ever a company that should make sure that they are following those rules, it's the federal government. And so understand that employees tend to not realize this until much later in the process. And then the moment they realize, wait a second, I might be a victim of discrimination, or maybe this disciplinary action is unfair in some ways, there are some very tight timelines for them to do something about it. And if they wait too long, they might be out of luck.
Yeah, and I would assume that a lot of folks, especially if they're currently employed, right? It's a one issue if they're no longer employed by the government, but if they're currently employed, I got to think that there's maybe an internal struggle going on with some of these folks as to whether or not they should pursue a case or an action or even a consultation, because maybe they like a person, or maybe they're worried about, their reputation, and how that might follow them to their next job. Do you find that a lot of the folks that you've represented over the years or represent now, they struggle with those things kind of internally?
100%, Matt. Absolutely. Nobody wants to create conflict in the workplace. I mean, I guess there's always the few handful of people who thrive on drama, but the vast majority of people do not. They don't like it. And remember, when we're talking about discrimination, and I've seen this again, we're talking, for 21 years, I've dealt with being on the government side of this, and we're talking about discrimination complaints, and it feels very emotional. First of all, it's very emotional and personal to the employee who's suffering under this. But it's received as very emotional and personal to the manager who receives the complaint and is told, "Hey, Mr. Smith has alleged that you discriminated against him, or Mrs. Smith, has alleged something about her treatment or harassment in the workplace." And so there's definitely a strategy here in some cases to decide, when do you get your attorney openly involved, and when to use the attorney you've hired to stay in the background and help you work through this so that you're not creating unnecessary conflict? Because what we don't want is, we don't want to throw gasoline on a fire that's already there. And sometimes we might have to do that. I mean, at the end of the day, the heart of the matter is that my job is to act in the best interest of my client. Sometimes that's waiting in the wings and knowing when to come out swinging. And sometimes it's coming out swinging on day one because somebody is being victimized through a supervisor who's putting them through their paces, and it's unacceptable. And sometimes the only way to stop it is to come out hard and fast and make sure that supervisor understands they're on the wrong side of the law, and they better correct themselves quickly.
And Chris, I think that's where your experience being on the government side of this for as long as you were comes into play, because you can really understand both sides. Much like a prosecutor who then, becomes a defense lawyer, right? It's important to understand both sides, how both sides think, and it does give you a level of expertise, right? And I guess to that point, Chris, talk to us a little bit about the difference between taking a case to the MSPB versus the EEOC route, and then tell us just about the processes involved in either one.
Absolutely. So I totally agree with you, Rob. Seeing both sides of it makes a difference. I really did enjoy working for the government because I could make sure that the supervisors, managers, commanders that I advised were always on the right side of the law. And I liked being in a position to help guide them to make sure that they weren't creating toxic or hostile environments for employees. And if frankly, the agency was doing that, how they can fix the supervisor or potentially even discipline the supervisor if they did something wrong. So I really did enjoy that. And I do think it brings a lot to the table when you have somebody who's seen both sides of it, as I have both in federal employment law and in the criminal side of things. So the difference between the Merit Systems Protection Board, which we'll talk about as the MSPB, and the EEOC process, there are some major differences. The first is timing. So in an MSPB case, from when you file an appeal to when you have a hearing is usually within 4 to 5 months. So that is really quick when we think about lawsuits. And I think you probably can understand that, Rob, in all of your experience.
I can.
to think, right?
Yeah.
From day one to a hearing, 4 months is nothing. I mean, that goes by in a flash.
Yeah, absolutely.
So that's a huge advantage sometimes, depending on the client, to be able to get vindication really quickly and to get a resolution really quickly. That's an advantage. The EEOC process, just because of the numbers of complaints that are filed each and every day and the investigations and that informal process that's held by the agency, which we haven't quite talked about, that is much longer and could be 1.5 to 2 years out from when you file a complaint to when you actually see a judge in a hearing. So that is a huge difference between the two.
So we understand now the different processes. We understand, how they're different. Talk to us about, what are kind of the common situations of discrimination that you've seen, and then talk to us about how you typically handle those kind of cases.
Sure, absolutely. So I think some common situations, let's say for discrimination, the most common that I see are harassment cases. This is kind of what Matt was talking about earlier, right? This is the situation where the employee's coming in and day out, and they feel like, again, there's maybe you might use the word bullying. Maybe you might talk about inappropriate jokes or inappropriate behaviors in the workplace, where it's not that someone has done something to you that is clearly, patently offensive and criminal. But we're talking about day in and day out. You can imagine somebody who's getting ready to get in their car and they're having to take a big sigh and go, another day of this. Those are the situations that I think are pretty common, usually based on what I would describe as sexual harassment, which doesn't necessarily mean somebody's hitting on you, but somebody being inappropriate based on your gender, your sex, where you're dealing with someone who might be touching you inappropriately. We're talking about jokes that are inappropriate. And again, we would describe this as a pervasive situation where it's taking place over weeks, maybe even months of your job. And it's really changing what you signed up for. You signed up to show up to the Department of Veterans Affairs or to show up to the Environmental Protection Agency and do some good work each and every day. And now it's being limited by what you have to put up with. So I think harassment based on whether it's based on your race, based on the sex or gender you are, based on, maybe if you come from another country and you have a bit of an accent and people make fun of you for it, that is unacceptable. So I think that's one of the main complaints we see, because again, it is this undercurrent of what this person faces every day.
That makes a lot of sense to me. And so if you're, talk a little bit about what kind of remedies are available for these federal employees who are facing harassment or some kind of discrimination in the workplace. What's out there? How can they be compensated? How can they be made whole, for lack of a better term?
Well, that's there's a lot of options for how they can be made whole. So if I'm representing somebody who has been harassed in the workplace, regardless of what the basis of harassment is, if I'm representing somebody, the goal is to achieve their goals, and usually their goals are, one, I want this harassment to stop. Okay, so how do we make it stop? Well, if it's a supervisor, maybe you need a new supervisor. Maybe that person needs to be corrected. Maybe that person needs to be disciplined or even fired. If it's a coworker, now we're going to talk about, okay, can we move this coworker? Because a lot of folks, this is somebody they're seeing every day.
Right.
So even if the harassment stops, that's really not making them whole, because each and every day they're walking down the hallway and they have to make eyes with this person who has bullied them for this long. And so maybe it's a solution of moving that employee somewhere else, not moving my client because my client hasn't done anything wrong, but moving that harasser somewhere else, giving them a different job, moving them so they don't have to deal with them each and every day. There's the ability to be compensated. A lot of employees might have to get mental health treatment or see a therapist. And if that involves some sort of medical costs, well, they can get reimbursed for that potentially. Another option, and fortunately, and this is a benefit of being a federal employee, is if there's a finding of harassment against one of my clients, they're entitled to attorney's fees. And so while they've decided this is important enough to fight, they've talked to me, they've paid our retainer, all of those costs that we've incurred, whether it's the lawyer or the entire legal team, they can be reimbursed on the back end if there's a judgment against them. And so that's another avenue to say, hey, this is something that you've invested in to see it through, and it's something you can be reimbursed for. I think that's really important. And then again, I think everybody knows about, non-economic damages that are out there. The idea of what is it? The government can't give you your feelings back. The government can't fix that anxiety diagnosis you have or the PTSD diagnosis you have from whatever you've put up with. But what they can do is say, well, maybe there's an amount of money that it might not make you whole. And I got to tell you, Rob, I appreciate you using that term. How do we make this person whole? But you can't change someone's, chemistry
Right.
after they have anxiety of going in and day out.
Right.
What you can do is maybe give them some amount of money to at least try to make it up to them the best the government can. And so that's another avenue of redress, we would call it, or damages that one of these employees could get going through this process. And that's not just through a judgment in front of a judge. Obviously, along this process, if we've set up the right strategy, and if you have an attorney who can lean forward and have a strategy for that hearing and put you in a position of strength, that is going to be huge, because once an agency attorney sees what they're dealing with and sees the experience they're dealing with, on your side representing a client, hopefully we can get a resolution sooner than that year and a half or 2 years down the road. And maybe there's a settlement that the client is going to be happy with. Maybe not, and that's okay. But you want an attorney who's going to see you through.
Now, Chris, you've done this on both sides of the aisle, right? What are some common pitfalls that you see that could hurt the plaintiff or hurt the employee or the client who hires us to represent them through these difficult situations?
Well, the biggest pitfall is probably waiting too long to get an attorney. We talked about all the agency processes and the administrative processes through these types of complaints. And so too often I see employees who go through those processes by themselves. And so when they finally say, you know what, this is too much for me, I think I need an attorney, I can't describe it as any other way than it boxes me in a little bit. Because that entire time that they've gone through the process, they have made statements, they've provided a complaint, maybe there's a claim out there that is limiting in some way. And so I'm now boxed into what you've done as the employee for the past 3 to 6 months. And that I say that not in an avenue of blaming the employee. I completely understand why. Again, we just talked about this, right? People don't want to be confrontational. People don't. They inherently avoid conflict, right? And so I don't blame any employee for waiting too long, but I gotta tell you, it only hurts their case. It only limits their case and the avenues we can use to make them whole again.
Now, that makes a lot of sense to me. How can choosing the wrong attorney impact a case negatively?
Well, we've already talked. We've talked about two main forums by which an employee can complain. Right? We've talked about the MSPB. We've talked about the EEOC. But there's other options that are out there that might be less common, but they're out there. There are times when you can sue in federal district court. So you need an attorney who's comfortable in that arena and in that district that you're in. There are times, depending on your complaint, that you might be dealing with the Department of Labor. Maybe you're dealing with the Federal Labor Relations Authority because you're a bargaining unit employee. Maybe you're dealing with the Office of Special Counsel that really focuses on whistleblower complaints. And maybe you don't even know that you are a whistleblower and that you have this right to file a whistleblower retaliation complaint. And so I think it's important to find an attorney that is not only aware of all these options, but comfortable in all of these different arenas, because you want somebody who's going to be able to sit down and identify, here's the strategy. And while you have a couple of options, here's why this option is the best strategy for your case, because every case is different. Every client is different, and every goal of a client is different. And so you want somebody who's going to work with you on day one to figure that out and then navigate that perfect path for you.
Now, Chris, we've talked. Go ahead.
No, I was going to just throw out one other thing to consider, which is when we're talking about discrimination complaints, for example. One of the things we've hit on is that investigation. The agencies have to investigate discrimination complaints, and that's why you have to bring your claim to an agency EEOC investigator. Those investigations take about 6 months, but I'm sure you can imagine those people, just like other federal employees, are overworked. They're asked to do more with less each and every day. And so instead of falling into the pitfall of waiting too long or trusting that investigation, one of the things we get to do, at least with Capovilla and Williams, not only do we have a team of attorneys and paralegals, but we also have a team of investigators. So if an employee hires us on the front end, I think I'm being harassed, I think I'm being discriminated against, what can Capovilla and Williams do for me, or what can Chris do for me? one of the first things we're going to do is we're going to investigate and gather that evidence because I will tell you, the majority of discrimination complaints end up being dismissed because there isn't a suitable investigation to show a connection between the actions of that supervisor or coworker and a motivation to discriminate. And that's something we can do on the front end and put that on a silver platter for the agency investigators.
I think that's really well said. And, we are fortunate. We've got 4 investigators that all work for the federal government. We're trained by the federal government on how to conduct investigations. And there's no doubt that part of the results that we get are because we make the investment into those investigators. They're very good at our jobs and they help our clients. But I want to shift gears here for a second, Chris. We've talked a lot about discrimination and how those cases are handled. You also talked earlier in the episode about federal employees possibly facing discipline. What rights does the employee get if they're accused of misconduct?
Well, federal employees get due process, and that's a good thing. Due process, right, to make sure that they get a right to respond, they get a right to look at the evidence, and potentially, depending on what the final decision is, they get the right to appeal to the MSPB. But it's almost like 2 different cases. It's the right to respond to discipline in that process, and then you have a right to appeal on the back end. So there's really 2 bites at the apple for federal employees.
And so, talking more in the discipline arena, if they are accused of some kind of misconduct, like we talked about, what should they do? What's the first things they should do?
Well, I would say the first thing they should do is consider hiring an attorney. It's one thing when an employee maybe gets a counseling, right? And maybe they get a counseling, and maybe the employee thinks it's perfectly legitimate. They made a mistake, and they're being corrected and being put on the right path. That's fair. They can handle that by themselves most of the time without question. But when you're talking about maybe a reprimand, or more importantly, maybe a suspension, they are now on the path to losing their job. And that is a real concern. And in the moment, again, you can imagine emotions are running high. They might think, well, I can handle this by myself. But the first thing they should do is get an attorney, because the moment they start facing losing their job, losing their income, and the effects that has on a family. I mean, we're currently talking about, in the past few months, tens of thousands of employees have been fired or been pushed out through early retirement, pushed out through the deferred resignation program. This is a stressful time for federal employees, and it's really important to not wait to have somebody analyze your case who's looking out for your best interests, to make sure that you're setting yourself up in the best position so you don't lose your job.
Chris, let me jump back in here and just maybe back up a second, because I always think about, as the layperson here, I always think about kind of that employee who is facing discipline or investigation. Can you talk a little bit about the most common types, and maybe even give us some specific examples of, here are the things that I see or I've seen most often in my career that employees get investigated for? And then the other is, how do they find out about it? I mean, I always imagine, I know with Rob's military justice cases, a guy's at work and all of a sudden he just gets pulled out by command and says, hey, come on, we're going to CID or whatever. How does it work with federal employees? Is somebody sitting at their desk and all of a sudden somebody taps them on the shoulder? Can you talk about how they get notice of it? And then can you talk about maybe some common examples that you might get investigated for?
Oh, absolutely. So certainly, just like in the military, just like at any private company, there's a process by which, if somebody gets reprimanded for something and there's, they're written up, I'm going to say that in quotes, they're written up by their supervisor. Normally it's because it's a feedback session with their supervisor. They're issued a letter of reprimand, let's say, or maybe a letter of admonishment. And this could be for any number of things. Usually I see this I'm going to describe kind of the workplace issues. We're talking about you've missed a deadline, you haven't responded to your boss in a timely manner, you're showing up late. Those tend to be the issues that get, written up. And it usually stays at that, I'm going to say, just at that paperwork level. It's on your file for a period of time. But other than that, it doesn't directly affect the bottom line of the employee. I think it's important to make sure you have somebody fighting for you in those situations. But again, those tend to be more minor infractions. In the military, we might talk about an Article 15. We might talk about demoting somebody. Well, in the federal employment realm, the real issues come when somebody's suspended, because a suspension comes with losing pay. And now we're talking serious misconduct that has serious ramifications. I tend to see this for inappropriate behaviors in the workplace. I tend to see this for the people who harass other employees. I tend to see this for people who are AWOL for a period of time. You can imagine if you don't show up for work for a few days, there could be some valid reasons for it, but the employee usually gets notified if there's an investigation pending against them, and they're the last part of the investigation. And Matt, can you imagine, right? You were talking about as a layperson. I want you to imagine when you get called in by somebody because they want to interview you as part of an investigation, and you realize you're the last person they've interviewed. They've interviewed your coworkers. They've interviewed your boss. They've gathered your emails or your time cards. They've done all of that. The fact that they're talking to you, Matt, says they're at the final stages. You're already behind the eight.
Yeah, but the average employee doesn't know that, right? And we actually just had an episode. Right. We just had a military justice episode earlier today where we talked about the fact that, you know, the accused is the last that they talk to. But a lot of people don't know that, right? They might very well think that they're the first person, or that, you know, this isn't going anywhere. It's a minor issue, right? I mean, you know, and I guess that goes to the idea of why you need legal counsel. But the average person doesn't know how that investigation has played out, you know, because you've done it for so many years, right?
That's exactly right. And then again, I don't even mean to make it scary for you, Matt, but not only might they not know that, what that also means is that after they get interviewed and they get served with their suspension, they might have anywhere between 5 or 7 days to respond. So we are suddenly at the verge of potentially losing their job. They're being notified they're definitely losing, whether it's a couple days or maybe even a couple weeks of pay. And this is now going to be on their permanent record. And they only have 5 to 7 days to respond once they get notified. So you're absolutely right. Most employees don't realize they're the last person to be interviewed. Most employees might think that's the start of the investigation, and they have time to figure out what they want to do over the next couple of months. And unfortunately, the truth is, Matt, they don't.
Okay, so let me just give you a scenario. I'm sitting at my desk. I've engaged in, you know, text messages, not on a government device, but my own device with some coworkers. I've sent some inappropriate things. I'm sitting at my desk. I get tapped on the shoulder by my boss. They say, "Come on, we're going to go talk." They bring me in a room. They confront me with whatever, and they suspend me. I mean, is that how it can go down, or is it different than that?
It's pretty close, Matt. So yeah, they're going to tap you on the shoulder. You're going to be brought into an investigator, depending on what you're being accused of. But in this case, you're talking about, you know, sending inappropriate text messages or saying inappropriate things. So they're going to ask you about that. They probably already have the text messages, right? So you're already you're already behind the 8 ball a little bit.
What should somebody do what should somebody do at that point? Should they say, "Well, hold on a second. I'm not going to give any statements"? I mean, that's hard to do. So can you just, I'm sorry, when on these podcasts, I just love to kind of dig into, this is real world, how it happens, and what somebody should try to be doing or try to be thinking, if at all, you know, possible in the moment.
Well, let me share you even just a little bit, Matt, because I know we do a lot of military law. I know that's what Rob is very familiar with, very experienced in. Federal employees have to cooperate with an investigation. If they're not being accused of a crime and they're going to be arrested, triggering their Miranda warnings, right? If you're being brought in to explain yourself and you're being accused of acting inappropriately, you don't get the right to say, "Hey, I have a right to remain silent." You've got to cooperate in an investigation because you're not being criminally charged with anything. This is a workplace matter. So think how scary that is. It's not as if we can do a timeout. Let me be notified of all my rights. Let me sit back and talk to an attorney. Let me have a notice of representation. No, in that moment, if you walk away and you don't cooperate in the investigation, and again, this depends on what you're being accused of. But if there's an outburst in the workplace and they want to call in every single person who saw your outburst, when they call you in, if you choose to say, I don't want to say anything that might hurt me and hurt my, potentially result in discipline. They're going to say, okay, well, now we're going to accuse you not only of having an inappropriate outburst in the workplace, but for failing to cooperate in an investigation. Does that blow your mind, Rob?
Yeah, no, that does blow my mind a little bit as a guy who's made his living in the military and federal defense world. But it makes sense, right? If it's not a crime and you get your paycheck from other people's tax dollars, it makes sense that you've got to cooperate so long as the Miranda warnings are not required. My question for you, Chris, is okay. There's alleged misconduct. Investigation happens. Investigation closes. There are adverse findings. Do our clients have the opportunity to respond to an investigation that says, hey, we think you might have done something wrong?
Yes, absolutely. And that is the 5 to 7 days that I estimated most employees are going to get. It changes by agency. It changes if you're a bargaining unit employee, depending on the contract between the union and the organization. But generally, it's about a week that you'll have a chance to respond. So you'll be given the evidence that they're relying on. You're going to be told what you're being accused of, and you're going to be told what the proposed punishment is. And in most cases, it is going to be your immediate supervisor who is proposing this, who's going to say, hey, Rob, you had this outburst in the workplace. I'm proposing your suspension for 14 days because of your unprofessional behavior. Here's all the evidence and statements I have. You have 1 week to tell me what should be considered, because then I'm going to send it to your next level supervisor to make a final decision in this case.
I see.
And so the employee's going to have that chance to provide a response. They're going to be provided a chance to give an oral response to it. And then all of that is packaged and it's handed to that deciding official, right? That higher level supervisor to look at all of those things and then to analyze what we call the Douglas factors. And the Douglas factors, and I don't want to get too much in the weeds, but the Douglas factors are a list of 12 things that supervisors must consider before making a final decision. So you want to make sure that you understand what is going to be considered before you give them that response, right? Because if you don't know what they're going to be thinking about, how can you provide a meaningful response?
And Chris, how do you help your clients with that response? I mean, what's the lawyer's role in that process?
I think it's really twofold. One, you want a lawyer who's going to be able to go through and analyze if there's any legal issues. Make sure that the process is being followed. You're getting the right to respond. You're getting the right time. They're giving you the right notification of rights. And between us, Rob, I could sit down right now, and if you gave me a notice of a proposed suspension, within only a matter of minutes, I could tell you if there's any red flags right off the bat based on that notification. And I think that's important for you to know someone who's going to be immediately able to see those issues. So the lawyer is going to be able to identify kind of any legal missteps by the agency. But then secondly, I would hope that your lawyer is able to then identify what are the issues and the interests of the agency in the suspension. It's very easy when we're talking about, hey, you've missed a few deadlines. I've already given you a reprimand that obviously didn't work. Now I'm suspending you. That's a pretty simple case. But for a lot of these, you really want a lawyer who's going to be able to step back and say, put themselves in the shoes of both the supervisor who's making the decision and the legal counsel who's going to be advising that supervisor. What are their interests? What are their goals? What are the consistency issues they have among their local agency? And say, how am I best positioned to respond to those people in their professional interests and also their personal interests?
Now, Chris, let's kind of move towards wrapping up our show. And really what I'm curious about is getting to learn a bit more about your motivations. As you and I were both JAG officers. I was a JAG officer in the Army. You were a JAG officer in the Air Force. And with that, we all know there comes opportunities and different ways that we can move our careers while we wear the uniform. You have extensive military justice experience. You were known in Air Force circles as one of the top, litigators in military justice matters. And yet, you decided to go into federal employment law, which, I imagine at the time, was a bit of a bold decision for you. What motivated you to get into this area of law? What motivated you to become, quite frankly, an expert in this area of law?
I will tell you, Rob, I've always loved litigation, and I appreciate the kind words about my experience. But for a lawyer, being in the courtroom is the finals, right? Being in the courtroom is the final battle between one side and another. And while there's so much that goes into any kind of conflict or confrontation or claim before you get into the courtroom is where it matters. And it was a tough decision to switch into federal employment law at the time when I didn't have the experience I have now in it. But it was all based on the fact that I enjoy being able to get up and fight when it counts. Where you're stuck in the moment. And Rob, you've been here countless times. You have seconds to object. You have witnesses who change their story on the stand, and you better deal with that in the moment. And you better be flexible. There's no timeouts. There's no opportunity to say, hey,
right.
You know what? My trial strategy has just been blown up by this witness. Can I have 2 days to figure out what I'm going to do? And you better deal with it in the moment.
That's right.
And that high strength, right, high reward system, that has always fascinated me, and I've always enjoyed that, no matter how much stress it is. So that was the one thing. And I will tell you, and I don't need to tell you, but the bottom line is it all comes down to fairness, due process, getting a fair deal for our clients, right? We talk about this, Rob, in all of our cases. And I go back to, if there's one side that gets no excuse for violating the law, it's the federal government.
I agree.
And so, absolutely. So, that was really important to me to make sure that our managers and my clients for the Air Force were doing the right thing. That was really, really important to me. And I found a lot of satisfaction in doing that. But you and I both know sometimes our clients don't take our advice.
That is also true.
Right?
Yeah.
And it applies when you're at the agency, right? Where a supervisor doesn't take my advice and it continues to hurt our employees. It continues to hurt morale. And that really is something that I've seen over the years in multiple agencies. And I want to put a stop to. The other thing I will just say is, just in the past 4 months, there's been a ton of changes in the federal government. And Matt, you might not be following along. I'm sure it's not exciting for you to read about new executive orders and changes to bargaining units across the federal government. That's probably not the news articles that you read about, but it's the stuff that I follow, and it's the stuff that is important to me. And there have been so many changes in the past 4 months, from changing how we hire and fire our probationary employees to changing which employees have the right to having union representation. These are massive changes. And I think it's really important to make sure that we are tracking all of that, and we are continuing to be able to advocate for our clients despite these changes, and also to be prepared for the changes that might be coming in the future. I think that's really important. And it feels very unfair to a lot of federal employees right now. And my heart goes out to them. And so I really like fighting for those people.
Yeah, well, I think that's evident, obviously, from the discussion that we've had today, and also obvious the other discussions that we've had. And that's part of, I think, what makes the firm different. Capovilla and Williams is you guys are passionate about this stuff, and maybe it wasn't your childhood dream to be a federal employment lawyer. Certainly wasn't mine to be a law firm marketer. But you get passionate about it, and you get into the work, and frankly, that's exactly what people need during certain times in their life. Is they need really committed professionals that are passionate about what they do. And certainly, sir, you are that. And we appreciate the episode today. I feel like we only scratched the surface on the employment stuff. We probably will do episodes on individual components of a lot of the stuff that we touched on today. But great episode, Chris. Welcome to the firm. It's great to have you. I know Rob's incredibly impressed with the work that you've done. I know Mickey loves having you on the team as well, as do the other guys. So we're going to let you go today, sir, because we know you got work to do, but it was great to have you on. Until next time, to our listeners, thanks for listening in. Another episode of Military Justice Today podcast. We'll see y'all later. Take care. Be safe.
Thanks for listening to the Military Justice Today podcast with your hosts, Robert Capovilla and Mickey Williams. This show was made possible in part by the law firm of Capovilla and Williams. For more information or to listen to more episodes, visit militaryjusticetoday.com.